Hello, beautiful humans, and surprise, here we are, zero notice, but there was a huge filing in the Aaron Spencer case. So welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and unbelievably, just a testament to her power and absolute amazingness is my beautiful and brilliant co-host, Allie, 3 days fresh off surgery. And yet there she is, as beautiful and as spirited as ever. What's up, girl?
Hey, babe. Hey, all. Well, I look like death because I just
You look
took
beautiful.
my hair down. I haven't showered since surgery, although we tried to today. My husband actually, Bob can be very squeamish of like blood and injuries. And he's also very sensitive to he doesn't want to do anything that could hurt me. So, but he has been an amazing nurse. And he took off all my bandages today, got me all rebandaged up, ordered me some fresh, super comfy clothes that open up at the shoulder, like little post-surgery clothes, got me so comfortable. And, I assumed I'd be the perfect patient, but I was not the perfect patient. And my husband put up with it. At first, I was going to leave my camera off because
I can't talk shit because I am literally the worst sick in the whole world. Like, there is nobody more annoying than me than when I'm sick. So, whatever. Like, you're just a far more patient person than I am in general. So you put up with my shit when I'm sick. Like, I'm always dying, even though I got like a mild cold.
We're short on time.
We are.
And
so
I want to get right
to
it. And, I haven't fully read through, neither of us have fully read through the defense's response to the state's
We got too excited reading
motion,
through it. So
but
we're
we
like, let's
started
do it
getting
live. We got to do it live.
outraged.
All right. So if you guys are not familiar, again, this is our continuing coverage of the Aaron Spencer case down in Arkansas. There's been a bit of a back and forth going on between the defense and the state. There was a motion in limine that was filed by the defense. The state then responded to that. Now we're getting a reply from the defense to the state's response. And it's pretty tasty. It's pretty tasty. So we wanted to be the first to get it out to the world because we were really excited in reading it. So here's what we'll do. Do you want to alternate pages?
Yes.
Reading?
Should we, yes.
I think that there's enough of a kind of a background here that we don't necessarily need to give a background. Do you agree with that?
I agree.
Okay.
And we're short on time.
Right? So, okay. So what we have here again is the reply to the state's response to defendant's motion in limine to exclude evidence. And this was filed today at 10:53 a.m. So defendant Aaron Spencer, by and through his attorneys, Aaron Casanelli and Michael Kaiser, states for his reply to the defendant's motion in limine to exclude evidence as follows. Spencer is charged with second-degree murder of Michael Fosler, specifically that Spencer knowingly caused the death of Fosler under circumstances manifesting extreme indifference to the value of human life, citing Arkansas Code annotated section 5-10-103. Spencer has asserted the defenses of justification pursuant to Arkansas Code Section 5-2-607, wherein A, a person is justified in using deadly force upon another person if the person reasonably believes that that other person is, one, committing or about to commit a felony involving physical force or violence, two, using or about to use unlawful deadly physical force, or three, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Now, we don't have time to get into that, but Allie and I have long thoughts on that particular statement right there regarding what actually constitutes domestic abuse. But that's for a different live. So Spencer has also asserted a defense pursuant to Arkansas Code annotated 5-2-604. So A, that conduct would otherwise constitute an offense is justifiable when, one, the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and two, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. So both statutes are justifications under defenses, are justification defenses under Arkansas law, and that is according to Section 5-2-602. So, all right, your turn. Get to reading, girl. You're muted.
So hopefully the sound's all right, because I was like starting to feel flush all of a sudden, so I just took the headphones off.
Oh, you did? Yeah, you sound good.
And the microphone.
Oh, I have an echo.
It's probably because I'm now using the computer microphone. You mean for me?
Yeah. If I talk, you're hearing it. Why didn't you want to wear the headphones?
I was starting to feel like all of a sudden flush. So
Oh, really? Maybe this is too much. I can power through.
I mean,
Now your mic, you're muted. Okay, you're
I
back.
feel fine. I'm surprised all of a sudden that I feel flush. It was like weird.
Okay.
Talk. Let me see if I can hear you.
Testing 1 2 1 2.
I can softly hear you through the headphones. I'll bring them closer to me.
You don't really need to hear me. Do you want me to read this next page?
Yeah, and then I'll read the next one.
Okay. All right. So the state's charges require proof beyond a reasonable doubt. Hold on. Let me take this frame off real quick. It's blocking. Okay. The state's charges require proof beyond a reasonable doubt that Spencer knowingly caused Fosler's death by deliberately creating a risk that was practically certain to result in Fosler's death. See Turner v. State, a 2019 case. The state must further prove that Spencer did not act under the reasonable belief that Fosler was committing or about to commit a felony involving force or violence against Spencer or Spencer's child, or that Fosler was using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent public or private injury, and the desirability and urgency of avoiding it outweighed the injury sought to be prevented by the murder statute. Both defenses are to be submitted to the jury if there is any evidence admitted supporting the defense, and if so, the court shall charge the jury that any reasonable doubt on the issues requires the defendant to be acquitted, and that comes from Section 5-1-111C. Thus, the state must disprove these defenses beyond a reasonable doubt, and that comes from Schnarr v. State, a 2018 case. By statute, a justification such as self-defense is considered an element of the offense, and once raised, it must be disproved by the prosecution beyond a reasonable doubt. That's an important thing, and I want you to remember that. Okay, so their defense, in terms of them tendering that as a defense, now becomes part of the burden. Okay, so remember that. So
yeah, I was going to chime in and say the same thing. Like, that is very, very important, because look, I'm of the mindset, and I know Bob is as well, that this jury is going to want to not find Fosler guilty just because of the
Aaron,
circumstances.
Aaron
I
guilty.
mean,
Fosler's
Aaron,
dead.
sorry. Spencer guilty
Terrible,
just
terrible
because of the
Freudian slip.
circumstances. So if the defense can hand them something to hang their hats on as far as, you know, determining that the state failed to prove their burden beyond a reasonable doubt, you know, as long as there's something there, I think you've got the reverse situation that you usually have where it's so much where reasonable doubt doesn't mean reasonable doubt. And it's such an uphill battle for the defendant. I think as long as they give them law that works, again, so not asking them to nullify, but saying you can follow the law and here's how. With the state having to disprove beyond a reasonable doubt that that Aaron Spencer did not believe Michael Fosler was going to unalive or inflict serious injury on his child. They have to prove beyond a reasonable doubt that Aaron Spencer did not have reasonable belief that that was going to happen. And I just don't see, I just don't see how they're going to be able to do it. But
yeah, I mean, look, the scary thing about this for the Spencer family is you never know what a jury is going to do. You don't know. Like we had a very lengthy discussion with my father last night, briefing him on this case, not knowing this was getting filed today, but we had like an hour and a half discussion, and my dad's 80 years old. My dad has never heard of grooming. Like I started the whole conversation by asking my father, who again is 80, do you know what the term grooming means? Not in pertaining to your pets or, something of that nature or grooming yourself, but in terms of grooming another person. He's like, I have no idea. So, we kind of went through what the concept of it was. I don't know that it resonated initially with him in terms of what we were saying, just how coercive it is in terms of the coercive control aspect of grooming. And, we went through kind of the fact pattern. And, I have my positions in terms of when I think the clock should start in terms of, I don't believe that it matters at all how the child left the home. I believe that the clock starts in terms of what was going on in Aaron's mind in terms of reasonableness,
and
starts and finishes at the point that he sees Fosler with his daughter in his truck
and
at the
babe, it's
intersection.
not just your belief. The law does not care how she really came to left that house.
Right.
The law
I agree.
cares about what Mr. Spencer thought was possible, whether
Right.
his belief was reasonable. So it doesn't matter how she actually got out of the house. It matters whether his belief that either A, she was taken out under force or threat of force, or B, even if she left willfully, that the person who took her planned on unaliving her or, continually sexually assaulting her. So how she really left the house under the law is not relevant, just like it's not relevant all the other crimes that Fosler committed, unless Aaron Spencer knew about them. Because
Right.
it doesn't matter what he really did. It doesn't matter how horrible he really was. It matters what the defendant thought. So what's good
And
for the
knew what
goose,
his knowledge was.
right, what his knowledge was, or in this situation, what he reasonably believed
And
as
look,
far as
we
the,
understand in real life, of course it matters.
right.
But courtrooms in terms of what's going to be deemed relevant, that's
Under
simply
the
like,
law, it
and we've
doesn't matter.
explained it. We've explained it to y'all like that. Like Fosler's history, whatever it may be, is not coming in because of exactly what Allison just said. All right, back to the document. So, paragraph I: the state's factual resuscitation or recitation is misleading and omits material facts. The chain of events, which we were saying, like I like when we went through. Whoa, she's being attacked
I
by
have
the
a way to do it before.
headphones.
Wait.
Wow. Oh my God. So she has her arm in a sling. She cannot move. All right, here's what I want you to do. You read, I'll run down and I'll put those on your head. She can't even hear me.
Wait, me? Because I can't hear you.
I know. I'll run. Do you need help? You read, I'll come down and put those on your head.
All right, so I'll read one and you'll come help me, is what I think
Yes.
you said.
All right.
Okay.
Yes. Okay.
Oh, man. Oh, boy. Okay. Oh, although I can't scroll past the very first sentence. So we're going to read this first sentence and then we're going to talk. So the state's factual recitation is misleading and omits material facts. The chain of events that led to the death of Michael Fosler began in July of 2024 when he repeatedly, thanks, babe, violated Spencer's daughter, not, as the state would have it, when Spencer first learned of the horrors Fosler had perpetrated against his child. The chain of events that resulted in Fosler's death definitely began with Fosler repeatedly SAing a then 13-year-old and later 14-year-old child. The chain of events continued with Fosler being arrested and released for those crimes, yet continuing his manipulation and deception so that he could, let me pull it up on my end, he could continue assaulting the child until someone finally realized that he had taken her away from the home that night. So we're going to pause there.
Okay.
We're on the next page and then footnote 1.
Okay.
In footnote 1, it says, it seems the state is sensitive about the language used to describe the 67-year-old Fosler picking up his 14-year-old abuse victim so he could take her to another location to commit more sex crimes against her. But surely no one can argue that he did take her. I don't know why it says not.
He did not take her away from her home in his vehicle that night.
But he did. I think
But
did
he
not.
but surely no one can argue that he did not take her away from her home in his vehicle that night. Important sense to get right.
Yeah, let's reread it because that was crazy.
All right. So pick it up. Where was footnote 1?
First sentence.
Okay. All right.
Okay, and just turning back to that, I mean, all the defense is saying that they're not agreeing that the state is right about. They're not talking about how she actually left the house. They're just saying no one can argue with the fact that he took her from the house in his vehicle.
Right, and just understand they're still dealing with the initial aggressor aspect of it here. Like, so that's what they're dealing with in this portion. All right. Come on, babe. You know, if you want to meet your brother for dinner, we're going to have to speed it up, kid.
When Fosler realized that Spencer realized that he had taken control of her that night, he fled with her, refusing to surrender her. The chain of events that led to Fosler's death began and ended with Fosler's criminal acts. The state's suggestion that the chain of events that resulted in Fosler's murder was Spencer looking for information about Fosler from a mutual acquaintance is yet another attempt to distract from the chain of events that Michael Fosler started and perpetrated until his death. It is yet another deeply concerning indication of its failure to blame the blameworthy, yes, state, the dangerous pedophile, instead of the man who found his daughter under control of the pedophile. And while the pedophile was facing multiple life sentences and then some for his abuses of her. The state also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbotham, don't call anyone. Don't call the police.
Quote. That's quoted.
Quote, right. Although that is not precisely what Higginbotham told the police shortly after. When he came to speak with Higginbotham, the person through whom Fosler accessed the child, Spencer actually said, don't call anybody. He felt because a family member had been through a child SA incident and the local police department in this jurisdiction had re-victimized her instead of helping her. Okay, I see. So they're saying she felt. So Higginbotham told the police, according to this, that Spencer said, don't call anyone. And what she took from that is that the Spencers had felt that because another family member had been through this and was further victimized, they didn't want them calling anybody. She, Higginbotham, explained that Spencer had just learned of the assault from his daughter, although she, Higginbotham, did not seem to believe it was true, and he, Spencer, wanted Fosler's contact information.
Okay, so the state also admits the context as to the history of the family connection between the Spencers and Higginbotham and her role in the events that led to Fosler's abuse of the child. The state's response then purports to describe the events when officers arrived at Spencer's residence in regard to the R allegation. In addition to the family's knowledge of local law enforcement's failure to assist in a prior child SA investigation, Spencer knew that Fosler had a history in law enforcement and the military. Although the state focuses solely on Spencer's visceral reaction to learning details of his daughter's repeated R by Fosler, the reality is that within 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes or more talking with the officers about the family history, the situation that led to their child interacting with Fosler, and the information that the child had reported to her mother, while waiting on other officers to respond and filling other time with cordial discussion about everything from the military to animals to movies. Spencer and his wife invited officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officers' requests. After waiting nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case, so she would not be speaking to the child that day. She interviewed the Spencers, and they provided her with all of the information that she requested, including names. Oh, God. Can you hear that? Including names, contact information, and every detail they knew to that point. They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, and then they cordially departed. The state's
Now, this,
attempt.
oh, sorry, I was just going to say, and I'll start because I'll finish the sentence, that this next paragraph here, which Bob and I did read earlier, really goes to show that the state is being extremely disingenuous with the way that they framed this. And that should anger people, no matter what side of this you are presently at, no matter what possibilities you think, this should anger you. The state's attempt to reframe this interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his belief in the inadequacy of the judicial system is not just false, but completely tone deaf as to the situation the Spencer family suddenly faced and their fierce concern for their child. The state dismisses that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. It certainly doesn't acknowledge the more than hour of he and his wife providing officers with information they could to help put Fosler in jail. While Spencer was worried for his child and angry at his daughter's arrest, the person he felt protected the arrest and who they believe lied to officers, he was quickly calmed and cooperative. Now, footnote 2, I'll go to without Bob having to scroll because he's not there. Footnote 2 reads...
I'm back.
Okay.
Okay.
Spencer and his wife were both concerned that the person who contacted police had lied to them, as they knew she was not a mandatory reporter. They were not told she had spoken to a third party who is a mandatory reporter or any of the other context of that conversation. They believed she had previously misled them about their child. I'm going to repeat that. They believed she had previously misled them about their child and had concealed the child's victimization at the time at the hands of Fosler, her boyfriend.
Oh!
They were upset because it seemed, with the information they had at the time, that she was again deflecting from Fosler's actions by accusing someone in the Spencer family of wrongdoing. Okay, that is a huge
Huge.
context of
Huge.
him just being like, so who reported it? Who reported it? Who reported it? He wasn't just concerned because who reported it because he was angry someone reported it. He was wondering if it's the same person who had been, in their minds, protecting.
Complicit. Like they're sitting there thinking about this woman. Okay, this shit happened on your watch. There is no way she didn't know that this was going on. Like that's probably the conversations that are taking place between Aaron and Heather, right? I mean, that's what we would be saying if we
Right.
found this out. It's all happening over at their house under her watch, and we're to believe that she doesn't fucking know. Really?
Or
Okay,
suspect or
sure.
whatever.
Yeah, but
Right.
I mean, it's that thing. All right.
So, returning to the body, it's difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific and shocking circumstances. What Spencer said then, and believes still, is that a person has an absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have sex with him while awaiting trial for numerous sexual crimes against her when the judicial system cannot and will not protect them. I would have added here when he believes that a child, he has a right to protect when someone who very well may be intending to silence the only victim against him, took her in the middle of the night from her home. But proceeding on, and what matters is what actually happened, not what the state tries to piece together from picking and choosing words spoken months before the events that put the child directly within control of her rapist. Now, when she says here what really happens, she means what really happened with Aaron Spencer. Because again, don't forget, the state is trying to use his request for information, his implying that he wanted to take the...
Right. They're trying to turn him into a vigilante.
Right. So
simply put,
that's different than what I was saying earlier about what really happened. They're talking about what actually happened with Spencer that the state's trying to put in. So what really happened is that Spencer stood down. He did not attack Fosler when he confirmed his contact information. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this that she was about to go through, officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. They did interviews, delivered and consented to searches of electronics, provided witness information, etc.
Fosler was arrested 4 days after the initial meeting at the Spencer's residence. He was seen by a judge the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond. And this is shocking. This is new information to us. And a generic no contact order prohibiting Fosler's contact with any minor. It was not specific to the Spencer's child, the victim, and it did not include any restriction concerning their property or other places that the child may be present. That is mind-blowing.
Exactly.
It is disgusting.
Such a failure.
I do not know how this judge is on the bench. This is a catastrophic, an absolutely catastrophic mistake by this judge. Why she wouldn't have it pertain? She can say it's pertaining to the Spencer's daughters and all other children, but to not have it specifically protect the child who is alleged to have been abused is outrageous.
Nothing about cannot come within 500 feet, 1,000 feet of the home, 500 feet of the child, where she works, where she goes to school. I mean, that is typical language. This is a complete failure of our justice system to protect victims. And now, once re-victimized, they have the audacity, the fucking audacity to charge the father for protecting the child when they wouldn't. Now, look, at the end of the day, there was still an order of protection that prevented him from contacting her because it prevented contact from all children. But what also should have been in there, and it also prevents him from going to her home because it prevents him from having contact with all children. But it should have been explicit, as Bob is saying, to the child, to her place of where she lives, where she works, where she goes to school, anywhere she is present. And it gets even worse.
It gets worse. So despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in the use of social media. He was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movement were monitored in any way. I'm going to read that again because we're talking about a guy who was charged with, 20 plus CSAM charges. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in the use of his social media. He was not required to report to anyone associated with the court or law enforcement, meaning that he didn't have reporting. He wasn't like he didn't have to report to anybody in terms of any kind of
Probation officer, pretrial probation officer,
anybody.
pretrial services. And I want to address true crime. Is that fraud?
That's DB. That's DB.
Okay, DB's comment. Isn't the child's ID and address protected against the offender? Yes. But what they do in these cases is they say that he can have no contact with her initials. I mean, he obviously knows who he is charged with assaulting. And then they say that he cannot go within 500 feet of the home. And then, I don't know, typically what they do is they put an ankle bracelet on, and then they tell them where the 500 parameters are, but they don't tell them where within the 500 they can't, they don't give them the address. But in this case, he already knew where she lived, so that none of that would have mattered.
Clearly.
Yeah.
Yeah. And beyond that, when you have crimes like CSAM crimes, I have never, ever, if the person is out and they're able to make bond, I have never heard of a condition of bond allowing them unfettered use of the very tool that they used to commit the alleged crimes that they're pending trial for. I've never heard of it. It's
all
insane.
Sexual predators that I have ever come across have been limited in their ability to go online. They're not allowed to go online. They're not allowed to use social media.
Yeah, so he was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movement were monitored in any way. The state's response then begins to describe the early morning of October 8th of 2024 as if Spencer planned this night of his daughter being essayed by a 67-year-old man in order to efficiently and effectively, quote, take the law into his own hands. Such insinuation is offensive and absurd, and once again favors the pedophile instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much of its description of the morning Fosler died, and certainly omits significant information about the events that led to Fosler's death. See affidavit of warrant for arrest attached as Exhibit A.
And if you're not paying attention, start listening now because you're about to get more details, I think, than anyone's had about what happened or what has been claimed to have happened that night thus far.
So the affidavit states that Spencer told officers he had been woke up by his dog barking, which was uncommon, and went to check on his daughter due sick. There was a misspelling. The events that had occurred earlier in the year.
Now let's just start there. He specifically says the dog barking was uncommon. Now, what matters is what's in the mind of Aaron Spencer. And clearly, based on this comment, he thinks that someone came in his house because the dog was barking. At least once he puts it all together, that's the fair assumption because, that's the way dogs work. Our dog doesn't bark when we leave the house or when someone leaves the house. He barks when someone's coming near the house.
Right. 100%. only.
Yeah.
I mean, he'll whine. He'll
Well, he'll
whine when
whine
we're
if
moving.
you're outside and he's looking out the
If
window
I'm out
doing
playing
scout
catch or
play.
scout,
Oh
like,
boy, he
yeah, it's
cries.
a whole thing. It's a whole thing. It's like somebody's, cutting his legs off or something.
Right.
It's quite sad. All right, so Aaron Spencer stated that the dog was in his daughter's bedroom, and when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter in bed, he realized that it was actually a stuffed animal with his daughter's hoodie on it.
Now,
Aaron,
nobody tell me that a predator who comes in and kidnaps a child in the middle of the night, takes a child while they're sleeping by force, threat of force, drugs, whatever, that they can't just as easily put something in the bed to make it look like the child's in there. Just the mere fact that there's something in the bed doesn't mean the kid did it.
yeah, you know how many times Fosler probably watched Escape from Alcatraz with Clint Eastwood? Same shit, same exact shit. Like,
Everybody knows that's the oldest trick in the book. Stick something
right.
in
I
the
mean,
bed.
the guards are passing by his cell, and he like spent all that time making that paper mache dummy of himself. Yeah. All right. So at that point, Aaron Spencer stated that he became scared of what had happened to his daughter, and he had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fosler and his daughter. Now again, I'm going to remind you what we're reading now is from the affidavit that was attached to the state's filings. Okay.
Right. So we don't know how Aaron actually said it.
Right. So Aaron Spencer then stated that he left his residence and began to search for Michael Fosler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fosler turn off of Highway 31 North onto Highway 236 East, heading towards his residence. Aaron Spencer then stated that he turned around and attempted to stop the vehicle by flashing his lights and blowing his vehicle's horn. Aaron Spencer stated that he was in fear for his daughter's life and continued to pursue Michael Fosler east on Highway 236 East. So Aaron Spencer explained that when they arrived at the intersection of 236 East and Highway 13 North, he hit Michael Fosler's vehicle. What the hell? Just come on, dude. Be the right size. That he hit Michael Fosler's vehicle in the rear, causing it to slide off of the roadway. Aaron Spencer then stated that he exited his vehicle with his firearm in hand and ordered Michael Fosler out of his vehicle and to lay down in the ditch. Aaron Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fosler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fosler exited his vehicle and had something in his hand, but did not know what it was. Aaron Spencer stated that Michael Fosler then lunged toward him saying, "Fuck you!" Aaron Spencer stated that he then opened fire on Michael Fosler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer stated that he then got his daughter out of the vehicle and returned to his truck where he reloaded his weapon and called 911. Spencer certainly never told officers he thought Fosler had entered their home and forced their child into his truck. All right, you pick it up there, babe.
But when Heather and Aaron Spencer found their daughter's bed empty, they worried, given that what she had recently been through. They decided Heather would call 911 and he would begin searching the area. Now, look, I'm just going to pause right here because whether or not Spencer told the officers he thought Fosler entered their home and forced their child into the truck doesn't matter because he still could think so. And I think it's very reasonable to think so. But I'll continue to read. They decided Heather would call 911 and he would begin searching for her in the area. They learned that about that time from a family member that Fosler had recently contacted his child, and they were understandably panicked. They were terrified that Fosler would not only SA their child, but that he would kill her or disappear with her, knowing she was the critical witness to crimes that would put him in prison for the rest of his life. Like a normal family, Spencer left his
Like
wife
any
to
normal father.
reasonable. I'm
Like
sorry,
like any
reasonable.
normal like any normal fa I'm just telling you what it says. You said any normal family.
Oh, any normal father.
Yeah.
And I'm just going to say this. Good luck trying to prove beyond a reasonable doubt that that wasn't a reasonable thought, because that's what you guys have to remember. The state has to prove beyond a reasonable doubt that that thought right there at that moment in time was not reasonable. It doesn't matter if he's also angry. It doesn't matter if he's also enraged. It doesn't matter if he once thought about taking the law in his own hands, whether that means beating someone up or what it means, that's for another day. But if they can't prove that that fact, that information beyond a reasonable doubt wasn't reasonable for him to think, that it's not possibly thought it, and that thought is reasonable, he is not guilty. Period. The end. So, like any normal father, Spencer left his wife to stay on 911 while he went out searching for her. Contrary to the state's suggestions, there is absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what most of us would do. Contrary to the state's misrepresentations, in his interview after the shooting, Spencer did not say he was vigilant for Fosler that night. Again, people, if you're not paying attention, pay attention now, because we talked about this on a live before. And exactly like we said, the state again is being disingenuous in its manipulative wording and restating what was said. The motion goes on to say, instead, he explained that he learned what Foster looked like, where he lived, and what vehicle he drove because he was aware that no one was monitoring Foster. And while he did not watch Foster, he needed to know if Foster was nearby. He was worried that without any real barriers in place, Foster would seek the child out and hurt her again. He explained that he thought he had seen Foster driving near the Spencers' home several times, but he was not certain it was Foster, and if it was, Spencer would not confront him and instead would let the police do their job. But he remained aware of Foster and aware that no one was watching him. So, as he explained to investigators, Spencer stayed vigilant for Foster if he came near their home. Spencer said nothing to investigators about immediately getting in his truck that night to look for Foster because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Foster's truck as it turned on Highway 31, several miles from where the Spencer's residence is located on that roadway, and Spencer saw his child in Foster's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights. But Foster sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer had been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fosler's truck into a driveway. Fosler exited the truck coming towards Spencer aggressively with something in his hand, and Spencer shot him, unloading his clip. Fosler jumped into a ditch and continued to move and curse, and concerned that he may have had a weapon, Spencer hit Fosler with a gun to abate any further threat. To abate any further threat. I'm sorry, reasonable. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fosler with his daughter. Now, I'm just going to pause right here and say real briefly, let's think about when the police encounter a threat and when they think someone has a gun, or whether someone who just had a gun has been shot but is still moving and the gun is nearby them. They don't shoot to injure. They're trained to shoot to kill, to neutralize the threat, period. The end. And that's what I believe Spencer had every right to do at that point. And again, I'm going to say, if you're justified in the killing, it doesn't matter if it's overkill. It doesn't matter that either fear or rage drove you to overkill. It matters whether or not you were justified. It matters whether or not he was reasonable in his belief that this man might either unalive, disappear with forever, or physically cause injury to his child.
And never stop.
And
And
never
never
stop.
stop what he was doing.
This kind of hindsight is inappropriate and irrelevant. First and most importantly, there is no law whatsoever in the state of Arkansas that requires any citizen to call 911 in the face of imminent danger. Arkansas law provides every citizen the right to protect themselves and their family from threat of harm. There is no condition to call 911 first and see if that works out. Second, Heather Spencer had already called 911, and Spencer knew that. Unless the sheriff's officers were ignoring the call, they were on their way. If it takes a second 911 call to make officers move faster when a child victim/witness is in a pending felony case is missing, that is a significant problem for the community. Third, the state's representations about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone unlocked while driving, and also that he was going so fast he didn't want to have a wreck making a call. Not that he was driving so fast he could not unlock his phone. The phone records confirm that this is true. He made no calls between the time he located Fosler and the shooting. He spoke with a family member before finding Fosler with his daughter, and while a family member sent him a text during the interim time, the forensic examination does not establish that he saw those messages at the times she sent them. A critical review of phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use
the phone.
Do not reflect an action to use the phone to read the messages. Once he saved his daughter, his first and only call was to let his wife know she was safe, although he did not reach her. His next call was to 911. The state's assertion that Spencer, quote, had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night, end quote, is outrageous. It is as if the state is portraying this relationship between a child sex SA victim and her abuser as typical and consensual. The idea that a parent in this situation would reasonably believe that their child was safe in this circumstance is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstance had good reason to believe the child was in danger. This is especially true here, where the aurist with control over the child is facing life in prison and the child is the sole witness. Even though it matters not how you label it, most reasonable parents would believe this was a kidnapping too. Footnote 3 says the defense believes Fosler did legally kidnap the child and does not concede otherwise. However, it is irrelevant whether his conduct technically met the legal definition of kidnapping. And again, just to be clear, in Arkansas, you can't kidnap a 14-year-old unless it's through force or threat of force. If a 14-year-old goes without being forcibly or with the threat of force, it's not kidnapping under the law. So that's why they're making that distinction. But they're also saying we're also not conceding he didn't use force or the threat of force because he damn well could have. And it's reasonable to think he would have, especially after the child had already outcried, already been, talked to police, talked to parents, I think talked to doctors. She's not that same victim before. She doesn't want contact with him anymore. She doesn't want this anymore. And that's reasonable for the dad to assume.
So the comments also demonstrate a reprehensible blame the victim mentality. The state seems not to understand the victimization of children by pedophiles like Fosler. The child was 13 years old when Fosler began to groom. Get a little grooming definition down here, I imagine. Grooming is the behavior that manipulates and controls the child as well as those around the child to perpetrate the SA of said child.
And the best way to think about it, kind of, Bob, was we were talking about it yesterday, is like whatever methods that the perpetrator uses to ingratiate himself with the child,
Right.
whatever methods they might be. And that's grooming.
Okay, so the child was 13 years old when Foster began to groom and assault her, turning 14 years old shortly before he was arrested in July of 2024. Among many other things, he told her how often and how much he loved her and manipulated her into believing him and believing that she loved him, even when he hurt her, unfazed by the dozens of sex crimes he faced for his assaults against her and a no contact order prohibiting him from contacting a minor. Fosler continued the pattern of grooming, uh, the child so that he could maintain his ability to control her and violate her until the very end. Neither the Spencers nor any reasonable parent would ever consider the circumstances as just a teenager who, quote, snuck out of the house. The state seems to be arguing that it was unreasonable for Spencer to believe that Fosler presented a risk of harm to Spencer's 14-year-old daughter if he persuaded her to sneak out instead of forcing her out of the home.
And
The
that's an
state
if.
Right. The state also seems to be arguing that Fosler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and, at a minimum, have sex with her. But Fosler continued multiple felonies against this child that night. Yet the state seems to insinuate that Fosler did not, in fact, present a danger to his child victim on the night of October 8th of 2024, an insinuation that is so flabbergasting that it's difficult to comprehend.
I concur 100%.
So do I.
The state does not, however, offer the last piece of its theory that since, the state says, Spencer really believed the child willingly joined her arrest that night, he should have called the police a second time rather than follow Fosler and secure the child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fosler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any bearing on these issues. The only facts that matters are those that put a child victim under the sole control of a pedophile who had repeatedly harmed her. Spencer's anger months prior in no way changes the scenario Fosler created that night. Whether Fosler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so that he could continue to abuse her, if not disappear her, the analysis is the same. Either scenario created a legal duty and justification, and certainly reasonable cause, for Spencer to act to protect his child from a predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and witness to his crimes. The suggestion that if Spencer thought his 14-year-old daughter may have gone, quote, willingly with her arrest, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core issue in this case. Thus, it matters not what Spencer felt or said months prior when he learned of Fosler's grooming and abuse of his child. Because on the morning of October 8th, 2024, Fosler, by his own choice, posed an imminent threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her.
Okay, that's powerful. That's a good argument. I mean, the only thing that I will continue to argue is that I don't believe, as you stated, I don't believe how she left that house is relevant at all.
No, but
I would be filing a motion to eliminate to bar it because it doesn't matter how she left the house.
right, but what she said right there, she being the lawyer, is that the state's saying if Spencer thought his 14-year-old may have gone willingly. So they're not focusing on what really happened. They're focusing on what he thought. But
Well, I mean, there's only one person on the planet that knows.
exactly. So good luck when they know that they cannot prove this case beyond a reasonable doubt. I'm sorry, people. They cannot disprove beyond a reasonable doubt fact that Spencer thought his child did not go willingly. And I don't think that matters whether he thought that at the time or not, but just, just as one possibility, they can't prove that. And they also can't prove that he did not think reasonably that he was going to unalive her or continue to abuse her in such a way that required him to act imminently. He was about to be on a highway out of town.
All right. So, section 2, this is not proper 404B evidence. The evidence for trial, or the issue for trial, is not whether Spencer killed Fosler or whether he intended to kill him or planned to kill him or knowingly killed him. Thus, the 404B analysis does not apply. The issue is whether at the time of Spencer's action that he had a reasonable cause to believe that Fosler was committing or about to commit a felony involving physical force or violence, or was using or about to use unlawful deadly physical force, and or whether Spencer's conduct was necessary as an emergency measure to avoid imminent injury, where, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent injury to his daughter and or himself outweighed the injury to Fosler, and that comes from 5-2-604 and 607. There are complete, these are complete defenses. The state has to prove otherwise beyond a reasonable doubt in order to convict Spencer. And there's Anderson v. State, 2003 case. Justification is considered an element of the offense once raised and must be disproved by the prosecution beyond a reasonable doubt.
And I just want to finish what I started to say earlier. It's outrageous to me that the state, and maybe I did finish it and I didn't realize it, that the state would pursue these charges at risk of continued victimization of the real victim here, Spencer's daughter, when they know damn well they cannot prove beyond a reasonable doubt. They cannot disprove this information. They cannot disprove it beyond a reasonable doubt, and they damn well know it because they can't get in his mind.
Right. So, continuing in the body, Spencer did not, as the state insinuates, stalk Fosler and kill him. Spencer did not allow Fosler to kidnap his daughter and R her so that Spencer could kill him. Those suggestions are absurd. Fosler made the choice to violate the law and the court's order, and once again endanger his child victim. In fact, he was unrelenting in this regard. Fosler created and presented a real danger on the morning of October 8th of 2024, not Spencer. And therefore, Spencer's initial reaction months prior has no relevance to Spencer's necessary use of force months later. Unless the state is planning to present a theory that Spencer set Fosler up to take his child and assault her on the morning of October 8th of 2024 so that he could unalive Fosler, there is no legitimate 404B issue. The issue for trial is simply whether Spencer manifested extreme indifference to the value of human life or whether he may have had reasonable cause to fear for her safety at the time that he acted to protect his child.
Finish the next sentence. I'll do section 3.
Okay, so whether Spencer also hated Fosler or was angry at him after finding out about Fosler's horrific crimes does not impact this analysis. If he had reasonable cause to believe that Fosler posed an imminent threat to his child, he's not guilty. Whether or not months prior Spencer had said things in anger about not wanting police assistance or thinking it was bullshit to suggest that a person could not protect another person from harm without going to prison, the issue for the jury is whether Fosler's actions created reasonable cause for Spencer to act in fear for his child's safety on October 8th of 2024, allowing the state to taint the jury with emotional reactions untethered temporarily to the events of October 8th of 2024 violates Rule 404.
So I'm going to do a quick scenario because we've got to keep moving. But let's say that someone had, you're in a horror movie, right? Someone had tormented your family and tried to murder your children. You know who this person is. You at some point say you want to kill the person, right? And then on another occasion, horror movie style, you are being chased and tormented by a killer that when you finally somehow he's coming at you, you get your hands on a gun and you shoot 100 times. Does that mean that it wasn't reasonable to protect yourself and shoot him just because you overkilled? Just because you were either in fear or enraged, so you overkilled? That's what they're saying here. It does not matter, not what he thought before and not how angry or enraged he was that night. If it was reasonable that he thought he needed to act to protect, it was reasonable, whether or not there was overkill. And that's what they're going to have to drill into the jury. So Section 3, the state ignores Arkansas Rule of Evidence 403. The state completely ignores Arkansas Rule of Evidence 403 in its response. Even if relevant under 404B, evidence may still be excluded under Rule 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. They cite to an Arkansas case there. That is precisely the purpose and effect of the evidence at issue. Nothing about Spencer's comments in July of 2024 shed light on his actions or Fosler's actions on October 8th of 2024. Even in July of 2024, Spencer did not act upon his frustration or anger. He tried to identify Fosler's residence and his vehicle, and he went home. He thereafter consented to search and cooperated with investigators. He was, as any parent would be, diligent in trying to keep his daughter safe from Fosler, getting her therapy, limiting her contacts, homeschooling her, etc., and beginning to understand her suffering from the mental manipulation of this man. He was also, as any parent would be, diligent in learning information to identify the person who targeted and hurt his child so that his family would be aware if this man targeted her again. Fair. It was only when Fosler actually took his daughter from his home that Fosler presented an imminent danger to her that justified Spencer's actions to protect her. As it turns out, unbeknownst to the Spencers, Fosler had been communicating with the child since about a month after his release on bond. With no bond conditions or supervision dissuading him, he continued engaging with her and others on social media platforms and had directed the child as to keeping the communications secret. He had picked her up on 3 occasions between his release from custody and the night of October 7th, 2024, without anybody knowing. Wow. That's outrageous.
It's fucking insane.
On this final occasion, Fosler spent about 4 days or so persuading her to leave her house and go with him for the express purpose of committing criminal sexual acts with her, upon her. She left the house around midnight, and Fosler picked her up near the Spencer home. Fosler then drove her to his home in Cabot, S.A.ing her, was driving back near her home when Spencer encountered them. Spencer had no idea that Fosler had continued to communicate with his child after the arrest, and he certainly had no idea that he had continued to victimize her. Like any parent, Spencer went looking for his daughter when she was found to be missing. Once he saw Fosler with her in his custody, Fosler made clear he would not peacefully let her go. Like any parent in that moment, whether or not a 14-year-old child recognized the danger, her parents believed she was in danger in the custody of her arrest, and that Fosler had every reason to harm her to avoid life in prison. Fosler certainly did not, by his own behavior that night, indicate otherwise. To permit the state to try this case as a case of premeditation or intentional murder, as if there is no legitimate question as to the risk posed to the child victim that night, or as if Spencer somehow knew and planned to kill Fosler and allowed Fosler to harm his daughter again to do it, would be prejudicial error, allowing the state to try Spencer for his reaction to the initial disclosure of the abuse and the gory details, and not on the circumstances and actions that led to Fosler's death. There is absolutely no evidence to suggest Spencer knew Fosler would take control of the child and create a situation in which Spencer had to defend her, and to allow the state to suggest so is highly prejudicial and misleading. Spencer's comments in July are irrelevant to the issues in this case and threaten to confuse the issue for the jury's consideration and to mislead them into a fundamental misunderstanding of the law and how to apply the facts and how the facts apply to it. Conclusion: allowing the state to suggest that Spencer's actions to protect his child from her arrest were not motivated by concern for her safety at all, but instead by the panic, anger, fear, or frustration he expressed 3 months earlier would be prejudicial error. His comments upon learning that his child had been SA'd do not make it more or less likely that he reasonably believed she faced danger when Fosler had her in his control and refused to release her. Period. Any suggestion that those comments demonstrate an intention or plan to act months later, when Fosler actually had control of the child for the purposes of engaging in criminal acts, is illogical, unsupported by the circumstances, and would mislead the jury. Facts. The events of October 8th, 2024, Fosler's actions and Spencer's response to them are the relevant facts the jury must consider. The state should not be permitted to divert attention from those facts by implying that Spencer responded poorly or displayed bad character when he first learned of his daughter's victimization. Spencer did nothing to harm Fosler at that time, and instead he and his family cooperated with authorities prosecuting Fosler. It was not until Fosler put Spencer's child in danger again that Spencer acted to protect her. There was nothing vigilante about Spencer's actions to protect his child on October 8th, 2024. He acted in response to an obvious threat of harm. Although the state apparently disagrees with Spencer as to whether Arkansas law protects a person from prosecuting for protecting himself or his family when confronted with imminent danger that is uncontrolled by law enforcement or the judicial system, that decision is for a jury. Wherefore, the defendant, Aaron Spencer, asked this court to grant the defendant's motion in limine and for any other relief this court finds appropriate.
All right. So, I mean, it's a well-drafted pleading by Aaron or Michael, whichever one or both of them. And here's my bottom line with it. To be honest with you, I don't think, as much as I think that she should win the argument, I don't know that she will. I have a feeling that they're going to allow that shit to come in. But here's the thing. It doesn't matter. It doesn't matter, because the defense is going to be able to get all of the circumstances, the underlying circumstances that led up to that night. If you're under the impression that the state's going to be able to tell this theory and their story in a vacuum without including how it got to that point, you're dreaming, because that's coming in. It's relevant. It's coming in. So to me, again, as a parent, and maybe if you're not a parent out there, you don't know how this kind of hits home, because you can't imagine what it's like to have a kid. You have to have a kid to kind of understand how that love that's instantaneous the minute that you hold that child and is unconditional, how that makes you respond to certain things. You can maybe guess, but you can't know. And in this situation, Aaron Spencer did and said, in the moments that he found out that this happened to his daughter, exactly what any reasonable parent would do.
Right.
The things that he said were reasonable. His behavior with law enforcement was reasonable. And, she did a nice job of laying out how that thing really went with them, in that hour plus time that they spent with the cops cooperating.
Hey, so I'm gonna hop off because I'm feeling hot. Just do the supers and hop off. Love you guys. Thank you.
You did great, babe.
Thank you.
So yeah, I just, it's a powerful pleading. There's a lot of new info in here. There's a lot of new info in here. Things that we did not know. And, I saw DB asking questions, and they're relevant. They're good questions in terms of things that are being said with regard to what Aaron may have said. I don't know. I don't know if those are things that are caught on the body worn camera or not. I mean, that frankly, we're going to need to wait until trial to find out if those things were said, or if this is something that Aaron told her after the fact. Whatever the case may be, if it's something that he said after the fact and he gets on the stand to testify to it, well, they can cross-examine him on it. They can try to show that it's not truthful or that he's not credible at trial. Good luck with that, So, but I mean, it's a legitimate question. I think that ultimately there's going to be quite a few more motions in limine filed with respect to this case. I don't anticipate this is going to be the last one. There was another motion that was filed yesterday by the state, which I wish we had time to get to. Essentially, it was a very brief motion in limine wherein they are trying to bar 3 of the defense's expert witnesses. So I'm probably going to try to do a shorter live this weekend dealing with that. We just don't have time tonight because we're trying to meet my brother-in-law down in the city. It's 6:45 and we got to deal with Friday traffic. So, but we wanted to make sure to get this out to you. We felt that it was important for y'all to hear it. And it really does give some new facts. It really does. And it's interesting. And again, to me, I respect the fact that Aaron and Michael are fighting to keep that out. But I think at the end of the day, it might end up coming in. I think that there's a likelihood that it will. But I don't think that it matters. I don't think that it is going to persuade a jury one way or another because of, I think, what a normal response under those circumstances would be. And I think that the way Aaron acted was completely normal. Completely. Like, frankly, I was expecting him to be popping off way more than what we've seen in this particular pleading. So, and the one thing that we know that there is body worn cam from that entire meeting, I'm assuming for the whole hour and 8, maybe not, but I'm assuming it should have been on. So we would hope that it would be. That way that can get played for the jury and they can make their own decisions. But the time lapse in between the 3 months, it doesn't matter. Whatever he thought in the moment in time and when he learned about what had happened to his daughter is not relevant in terms of what happens 3 months later after this guy gets his filthy claws back in his daughter. So that's where I'm at with it. As Ali said, let me throw these supers up because we always appreciate that. Casey with just an amazing show of gratitude and incredible generosity, gifted 50 DD podcast memberships. Thank you, Casey at the bat. So much for that. That is amazing. Thank you for that. Decline coming in hot with $20 for the patient and the nurse. Love you both. Love you back, Decline. Thank you. Casey at the bat, excited to catch you live. Love you all. Family hugs. Oh, family hugs times 50 for you. Thank you. And then Andrea asked, get feeling better. Love you back. Thank you for your generosity. And then Brian is a wonderful, wonderful human being, like she always is, gifted 5 DD podcast memberships as a parting salvo. So we appreciate all of you guys so much. We adore you. Remember to like, share, and subscribe. If you're on replay crew, remember, just leave a comment in the algo. Helps get us, or a comment in the chat. It helps get us out to the algo, helps get this thing out. We want ears on this. We want eyes on it because we think that it deserves that type of recognition in terms of this case. It's worth people knowing about it. And the way that we do that is talking about it. We read through the pleadings. We talk about it. You guys discuss it in chat. It's a beautiful thing. All right, y'all. Mods, I'm sorry I gave you 0 notice, and I mean 0. Tracy's like, wait, are we live? She texted. I'm like, it was literally a snap decision. We're like, should we go live? All right, I'm going to go set it. And I went like 5 minutes later, we were live. So I didn't tell anybody. I apologize to all of you, my beautiful mods. And thank you for being here and doing the good work and keeping us happy and safe in this community, like always. All right, y'all. We love you so much because without you, I am just an old man talking about a lot of cases. Talking to you next.